Good afternoon, ladies and gentlemen. The chairperson of the East Africa Law Society Tax Law Committee, members of the committee, panelists for our session this afternoon. I welcome you on behalf of the President of the East Africa Law Society and Governing Council of the East Africa Law Society to this webinar that is focusing more on regional integration. And the focus today is the new common external tariff that came into operation in the EAC on 1st of July, 2022. So these new tariffs have created an additional band that goes to a maximum of 35% on goods coming from outside of the EAC. We are going to look at the implications of this new tax regime to the community, to the integration process, to trade, and our experts will also explain the opportunity for lawyers in terms of how do we advise our clients to better, get integrated into this new tax regime. So on this particular training, we have the chairperson of the Tax Law Committee, who will be leading the discussions. He's a senior tax expert, a very experienced practitioner from Uganda, Senior Cephas Berungi. I do not want to give an introduction of you. I believe you'll do better justice to it. So I call upon you to lead us in the discussions going forward. Thank you.
Thank you, David. Thank you, everybody. Thank you, our panelists and dear members of the ELS. I take this opportunity to thank the Committee for Tax on the ELS. I want to thank the ELS Secretariat for organizing this webinar. And I want to thank our honored presenters for taking off time to share with the rest of the legal community of East Africa. Welcome. Today, we have the following presenters: Mr. Jonathan Sesanga from the East African community. We have Lyra Latif from Kenya. We have Diodun Nzafashomwayo from Rwanda. We have Stanislas Timbo from Tanzania. So we have a wide range of presenters this afternoon, and we think we are going to do justice to the common East African customs tariff. I will not go so much into the details of the tariff because Jonathan will do that. But I want to first of all give some introduction about our presenters today. Mr. Jonathan Sesanga is a principal customs officer in charge of IT at the East African Customs Secretariat. He's a statistician with more than 20 years experience in IT, having worked on the ASCUDA system in Uganda, in the Uganda Revenue Authority, and then moved on to the EAC, where he has been a team leader and technical advisor, initiating and coordinating a range of projects, including feasibility study on interconnectivity of customs systems in the region, which developed the blueprint for transforming national customs processes into an integrated regional process, supporting the implementation of the single customs territory, using a seamless share information among the partner states. So he has worked on teams that assessed sector-specific outputs and inputs to guide tariff policy choices. He's also analyzed data for the Northern and Central Corridor time release studies, what is called TRS. He has a master's degree in Internet and Database Systems from London South Bank University. He has a bachelor's degree of Statistics and Applied Economics from Makerere University, Uganda. He has postgraduate diplomas in statistical computing and computer science, and he has a diploma in financial management from Makerere University and UMI. So, Jonathan, takes quite some time to finish your qualification. We have Laida Latif, who is an advocate, a lawyer in Kenya. Her legal practice focuses on company restructuring, contract negotiations, and asset-backed securities. She advises governments and international organizations on domestic revenue mobilization, taxation of digital business models, and metaverse-inspired NFTs, debt restructuring, and restraining illicit financial flows. She teaches in Nairobi and Warwick universities. We then have Deoden Zafashanwayo, who is a partner in ENS Africa, Rwanda. He has worked on M&A transactions, including private equity, sovereign investment funds, listed business in infrastructure and energy. He helps customers with PPP projects such as hydro and PV and HFO, and he has helped Rwanda's entry into company structures. He has consulted with Rwandan transfer pricing, in capitalization regulations, intra-group transactions, and employee stock ownership schemes. He has written for international and local media about tax, banking, business law, and employment law. He's a member, he has been recognized by Chambers Global and IFRL 1000 as a rising star. Welcome, Deoden. We also have Stanislas Chitimbo, who is the founder of Solid Attorneys, which is headquartered in Dar es Salaam and has branches in Arusha and Dodoma. Mr. Chitimbo is an advocate of the High Court of Tanzania. He's a tax lawyer and is a member of Tanganyika Law Society and East African Law Society, who is a member. So dear listeners, attendees today, we have a high-powered panel who will give us a lot of useful information for our presentation. As indicated earlier, we are going to have Mr. Jonathan Sesanga coming in first, and Jonathan will explain to us what the external tariff is, the new external tariff which was adopted in May 2020 at 35%. He'll give us highlights of that and other related matters about what is the common external tariff, how it applies, and what are the potential implications of that external tariff. After that, then we shall have responses on a country basis from our presenters, Deoden, Laida, and Chitimbo. Then we shall have a Q&A session, and then we shall finish with that. So without much ado, I would like to welcome our presenter from the ELS, Mr. Jonathan Sesanga.
Thanks, moderator. They have already introduced me. I'm going to take you through the new tariff 22. Let me display. Hope everyone can see that my presentation. Am I audible enough?
You are very audible, Jonathan. Cannot hear you.
Thanks, moderator. Yeah, the topic for discussion today is understanding the changes and implication of the new Common External Tariff 2022. My presentation is going to I'll give some highlights on what the Common Tariff entails, the overview of the CET 2022, and the rationale behind the new maximum tariff of 35%. Then I'll also take you through some of the products that have been classified under that fourth band, the maximum band. And then I'll also give you background on how that tariff was, the analysis that was done to arrive at the 35%. Now, the common external tariff is one of the key instruments under the Customs Union Protocol. And it specifies the rates, import rates that are applicable on goods which come from outside the region, the ESC region. So when you're under Customs Union, there's no import duty on goods produced within the partner states, but there is a common tariff that is followed to charge import duty on goods coming from outside the region. So that's one of the instruments, and actually it's derived from Article 12 of the Customs Union Protocol. So it came into effect in 2005, and that time there were only 3 bands: the zero rated, 10%, and a maximum of 25%. Then, in addition to what we call a sensitive list of goods which are protected because there are many produced locally, especially the agricultural sector goods. Now, still under the same protocol of the treaty provides for realignment of the tariff structure and rates to respond to global changes related to trade and the current economic environment, because you may want to know where the Secretariat and partner states derived the authority to change the tariff band. So it is provided for in the treaty and the Customs Union Protocol. So that's the background of the tariff. Now, as I've just mentioned, when the Customs Union was starting, there were mainly 3 bands: 0, 10, and 25%. 0 is for raw materials. 10% was for intermediate goods, and 25% was for finished products. However, over time, we noted that partner states were asking for state of application of the CET to allow them importing goods which are falling under the 25%. So what that meant is that we needed to come up with a proper categorization of goods, for example, which are either manufactured or produced in sufficient quantities in the region, and those maybe which are finished or manufactured goods which are available but not in sufficient quantities. So that's how we came up with the 25 and 35%. Now, 25% covers those goods which might not be in sufficient quantities in the region, but for those goods which we feel that they are produced or manufactured in sufficient quantities, they are the ones which have been categorized under 4th band. I'll demonstrate to you some of these goods so that you get to know why we arrived at that 35%. Maybe what I can also add is that the World Customs Organization comes up with what we call the product nomenclature, the definition and classification of goods. Now, it stops at 6 digits. So the partner states or countries, they add the 2 extra digits to cover their national classification. Now, for us in the region, we are using the 8 digit under the common external tariff. But from time to time, every 5 years, this tariff, there are new additional products which come on the market or changes in the trade patterns, which necessitate what we call transposition of the tariff. For the last tariff that we're having was tariff HS 2017. Now this year, we added, there are new products which came on the market, and the World Customs Organization advised us to include them. So it's applicable across the whole world. And So two things have happened at the same time, the transposition to HS 2022 and also the introduction of the 35% maximum tariff band. Now, assessment was done, and the rationale behind this maximum tariff rate of 35% is it, one, to reinforce, okay, it came into effect on 1st July 2022 to coincide with the beginning of the new financial year. And most partner states, their financial starts from July up to end of June. So it came into effect from 1st July to coincide with the new financial year. The objective was to reinforce national and regional policies of developing priority value chains. Then again, we looked at the expansion of intra-regional trade, because some countries have comparative advantage over others when it comes to some of the products I'm going to show you, such that instead of importing from outside the region, whereas other countries are producing the same goods, we noted that there's need, maybe by introducing 35%, it will maybe deter or promote the trading among partner states. There's also like need to diversify products, creation of jobs, and creation of opportunities in the informal trade, and sustenance of regional food security and rural development. Again, as I would demonstrate, it also helped partner states to maybe increase their revenue. And again, as I mentioned, that we have been getting a request of on the state of application of the CET rates for goods which are not in sufficient quantity. But we hope that the introduction of the fourth band, 35%, will minimize or reduce on these state of applications. Now, let me take you through quickly the demonstration of some of the products that have been that were classified under the fourth band. And as I mentioned, that these are goods which are manufactured or produced in the region, and we feel that there are insufficient quantities to be traded across partner states. Now, under Chapter 2, that's where the meat and other byproducts are classified. So there are 66 tariff lines under Chapter 2, products which are readily available, the meat products. And we made a comparison with other regional communities. Ours is 35, but other communities like Saku, the rate is 40% if you have to import those products into their meat into their region, and Ethiopia is charging 35%. Dairy produce, butter and dairy produce, and then products derived from milk. So we made a comparison with the Saku. They charge 79%, dairy spreads 37 to 79%, and then Ethiopia charges 35%. There are also products of animal origin which are not elsewhere specified or included. There are 7 tariff lines. So some of these products include the tourism. Actually, the 35% is aimed at the preservation of tourism and wildlife products. So I know ivory, this is a prohibited good, but there are other products which need to be protected. Also, there are also luxurious goods like human hair. So when you compare with Ethiopia, they are charging 35%. Then there's also live trees and other plants, for example, fresh cut flower exports. So if you are to import flowers into the region, they'll be charging 35% because flowers, there are partner states which are of comparative advantage when it comes to production of flowers. So if there's a shortage in one partner state, then another one can, then they can buy from another partner state at 0 rate, and as specified in the common external tariff. Now, there are also edible vegetables, avocados, edible fruits and nuts, bananas, pineapples. So there's no need of importing these products from outside the region when other partner states can produce them and you can get them at 0 rate. There are also coffee, tea, and spices, cereal products derived from cereals and milling industry, cooking oil. The countries have advantage. For example, in like Tanzania is very good at producing edible oil from plants, and other partner states are also producing from animal fat. Meat of fish and other aquatic invertebrates. So meat industry value chain, you note that if you are importing into SACU region, they charge 40% and Ethiopia 35%. Sugar and sugar confectionaries, coke and coke preparations, domestic biscuits, preparation of vegetable, fruit, nuts, packaging, tomato sauce. So these products, we noted that there's need to trade across the instead of importing them from outside the region. SACU, they charge 37%, Egypt 60%. Miscellaneous edible preparations, beverages, spirits, residues and waste from food industries, tobacco and manufactured tobacco substitutes, cement and other material used for plastering, paint. These are perfumes and the other toilet preparations or cosmetics, soap and soap products, pasting gunpowder, plastics, wood articles, paper boards, printed books, like postcards and materials, postcards, calendars, catalogs, and other printed material, packaging for industry, locally manufactured shoe, footwear, headgear. Now these are plastics, artificial plants and fruits. Now these are materials which are made out of plastics. Now, when it comes to building materials, under chapter 69, ceramic products, so it was noted that there's an increase in the capacity in the region. Iron and steel products, the 19 tariff lines, which fall under 35% now. Iron and steel, office furniture, miscellaneous manufactured articles like ballpoints. Now, in summary, this is the categorization as per the number of tariff lines of goods which are going to fall under that fourth band. And 338 tariff lines for agricultural processing or products under that category. chemicals, manufacturing, iron, steel processing, and then other mineral processing. So the goods which are targeted under 35%, they fall under those different categories. Now, during the assessment, the assessment also looked at the underpinning policy support. We compared the COMESA, SADC, ESC, and also national value chains. So each country is the comparison was made for on 5 partner states: Burundi, Kenya, Rwanda, Tanzania, and Uganda. So we looked at the priority value chains. So as listed there for each country. Now, as I mentioned, that partner states have been asking for stop application to import goods outside the region. And if you categorize them by tariff rate, like for example, the case of Kenya, the products under fourth band with rates above 25%. I think it has more above, in the category of 25%, 30, 35, and then 25. URT, 35%, and then also the Uganda. Now, consultations were made, and the private sector position is that they also recommended the maximum CET of 35%. And I think they are the same reasons like we have just mentioned above, that is promote value chain development, adequate tariff differential of 10% to create incentives, investment incentives, and expand supply capacities in agriculture and industrial development. Also, they acknowledge that the products proposed for fourth band are those sufficiently produced in the region. Hence, welfare erosion does not arise. Then promotion of extra-regional trade, as I mentioned, that some countries have comparative advantage over others in the production of the goods I've just listed above. So they can trade across within the partner states at 0 rate instead of importing from outside the region, and also to realign business environment with global developments and economic realities. That was the position of the EABC. Now, let me show you, take you through quickly the macroeconomic analysis that was done to, I'm going to highlight the impact of the 35% on the following parameters. One, oh, come again. So when it comes to revenue, actually, what maybe I need to point out here is that when the discussions were going on, 3 tariff, rates were proposed. One, some countries were going for 30%, others were going for 35%, then others decided to settle for the middle of 33%. But after discussions, the ministers agreed that they adopt the 35%. Now, analysis was done on the impacts on imports in the region and their implications on revenue, because if it was noted that if we increase for example, the rate to 30% from 25%, for Burundi, the import percentage volume will go down by 8%, by 0.8, and then the revenue also will, okay, it's like a trade-off. The imports might go down by that amount, but at the same time, those who continue importing under 30% will bring an extra 10.2. So that's what was done for even 33% and also 35%. So it was noted that for 35%, like country like Burundi will get more if these goods, because they are not prohibited goods, but what we are saying that at that rate, we want to reduce on the importation from our side, but it is estimated that those who will continue importing, the partner states will continue raising revenue. So a country like Burundi will under that will get 11.3%. Then I'm showing the column of the one of 35%, and the others as they follow below. Now, when it comes to the trade itself, the same analysis was done for each proposed rate. But for 35%, you note that now the imports, the volume of imports, the value of imports as of now under those goods which are categorized under 35. Now, this is a value of imports before. If you see, I don't know that this thing can highlight properly. Then after the introduction of 35%, the value will go down because the quantity will go down by minus 0.9%. And then it means that the savings from the reduction will create trade within the region of this 1.363 for Burundi, Kenya, as you see, going down. So it means that the trade diversion from the rest of the world, those who will stop importing from the rest of the world, this is what would be the value. Now, this is now the scenarios for the different category of goods per country. Now, this the graph I'm showing here is for Burundi, for wood, articles, and other products. For each category of, for each rate that is proposed, 35, 33, and 30. This is the one for Kenya, Rwanda, URT, and Uganda. Now, so it is according to the analysis that with the 35%, there will be more trade in those different categories of what? Goods. However, we noted that the reduction in trade might have an impact on the welfare of those who are trading those commodities. But it was noted that this is a temporary, downside of it. With the intended objective of increasing trade and the production in the region, this effect of welfare will be temporary for a short time. Then eventually the incomes will start increasing of those who are trading these commodities or producing these commodities. Now, this is the impact, the percentage impact on percentage change on industrialization, because if there's a reduction in the importation of these goods or production from outside the region, so what you're seeing in yellow is the bar which shows the percentage increase in the industrial production. And this is a breakdown of what I've just shown you there for each country. Now, when it comes to employment, what you're seeing in this should be the impact. It will result in increased employment, as you can see with this yellow bar, the one which shows the 35%. Now, this is a summary of what I've just explained above, that when it comes to tax revenue, at 35%, this is how the countries, the partner states, will gain from the increased, from 35% rate. Trade diversion or trade that will be created within the region is, as you see in the last column, I've already mentioned that there will be a welfare effect, but it is estimated that this will be temporary and eventually it will go up. Industrial production, those are the percentages, and then also the formal employment. Now, this graph shows you the EAC trade in the fourth band products from 2017 to 2021. So what you're seeing in the gray shaded bar, it is the trade in those products from the rest of the world, and then from within EAC is what you're seeing in green, and then from the rest of Africa is what you're seeing in blue. So it is estimated that when the 35% comes into effect, there will be an increase in the intra-regional trade. This bar, or the green bar, it will go up. And maybe there'll be a deduction in the other bars, which means that less of those goods will be imported from outside the region. So, moderator, that's the end of my presentation. Thanks for listening to me.
Thank you so much, Jonathan, for highlighting especially the criteria for and justification for the 35% external rate. I just wanted you to, before other questions come in later on, you mentioned two things which may not be very obvious to everybody. You mentioned the word state of application. I thought you may need to explain it a bit. And also you mentioned the SACU, maybe it's South Africa or something else, but I request that you just explain it a bit. Thank you.
Okay, thanks. Let me explain that straight away. State of application of the CET, for example, what that means is that partner states can apply. For example, if they want to import, for example, let me give an example of sugar. A partner state, if they want to import sugar, maybe because there's a shortage, and there might be a number of reasons why they want to import from outside the region. Now they apply to the Secretariat, to the Sectoral Council on Trade, to allow them to import those goods at zero rate, to alleviate a shortage that might arise because of maybe drought or what. So in the case, for example, of sugar. So when what happened that the applicable rate is reduced, it might go to zero. For example, if it was 25%, it might, the country might request that we want to import that particular item at zero rate, we want to import that particular item at 10% or another rate below the applicable rate. So that's what we call state of application of the CET. But also it doesn't work downwards. State of application can also work upwards. A country might say that for us, we have sufficient production, say, of iron bars. And then they say, instead of like charging 25%, as previously was, they say, for this particular year, we want to charge 35% for whoever importing, say, iron bars into our country. So that's what they call state of application with the CET. It has implications if you're a manufacturer. I don't know whether I should also go into that now, but let me also first explain SACU. SACU is South African Customs Union. There's a customs union covering South Africa and countries around South Africa, like Swaziland, Lesotho, Namibia, Botswana. Yeah, so those are countries which fall under SACU, South African Customs Union. Let me hope I've explained it.
You have explained it very well, but we have one more question from Emile Osiemo, who is asking about mobile phones. He says the rate in Kenya is 25%, while the rate in Uganda is 10%. I don't know whether this is something you can read the answer or you answer it later on. His
Mobile
question
phones.
is that comment on the implication of the 2022 CAT on mobile phones, since Kenya's rate is 25%, while Uganda's rate is 10%. I don't want to
Okay,
confirm
maybe
whether the question is factual or not factual, but I think you can comment on that.
Yeah, let me explain. What I know is that actually mobile phones are not supposed to be charged import duty. They fall under products which were which are zero rated for purposes of promoting ICT application. But the CET only covers import duty. It doesn't cover other taxes. So what has happened is that other partner states, they are charging VAT at importation on some of these goods, maybe including mobile phones. I'm not so sure about the rates, but this is what is happening in practice, that some partner states, they don't, everything is zero import duty, zero VAT. Others are charging VAT and maybe excise duty on some of these products. So you may find that mobile phones, some partner states have are charging, but the common external tariff is not supposed to be, it's zero rated. So this must be national applications.
Thank you, Jonathan. There are a few questions. Maybe one you don't have to answer immediately, but it relates to from Kibet Mutai. He's asking what are the implications of the CET to the tariff offer made under the AFCTA, African Common Market, AFCFTA. Please update us on this. So I think in a related where you can comment about other regional organizations like COMESA, SADC, PTA, in terms of customs, and with also this new Africa, the continental free trade area. So you may not answer that, may need some more time to prepare for that. The questions will keep coming. I'll address them later, but at this stage, we can have an input from our next presenter, who is Lyra from Kenya. Lyra, are you ready? Or as you come on, if you are not ready, Jonathan could answer one question, but it looks like Lyra is very ready. So Lyra, can you jump it right away? You're welcome.
Thank you very much. I'll probably just start off with my presentation and then handle the questions later, if that's okay, good chair. Great.
That's very okay, very okay.
Thank you, Chair, for the introduction, and to the organizing committee for having me here today. Good afternoon, colleagues. So I'll probably share brief insights into the Kenyan perspectives on the potential implications of the recently implemented CET 2022. Now, I do not have much to say about its adoption, save that the East Africa Community member states had varied positions on the tax rate, but have now settled on the 4 band rates ranging from 0% on, for example, pure breeding animals, to the maximum rate of 35% on meat and dairy products, which is a critical industry for EAC. And local farmers and industries must be protected if the region is to become, competitive. So this harmonization of regional tax rates has been ongoing for some time, and the implementation, in my view, is a right step towards regional integration, a move towards tax harmonization, which is very necessary for the region to prevent a race to the bottom by East Africa member states setting tax rates which would create unnecessary competition between member states. And we've already seen this is a problem for the fiscal state when it tries to entertain different tax rates within the region in which it is settled. And it basically allows foreign multinational corporations to come in for treaty shopping, which undermines the tax base of most of our countries, and also eliminates the small and medium-sized enterprises from becoming competitive. So I really think the CET is a step in the right direction. It is also a great move towards establishing the East Africa Community Customs Union. Now, with the new CET, it is still too early, right, to tell the full impact of the new import taxes. But what is apparent is that the rates protect local industries from competition arising from cheap imports, and also reduces the cost of inputs required by certain industries. Now, the rates, which we have seen, my colleague just before me, through his presentation, the rates basically provide an effective rate of protection to nascent industries, especially our upcoming garments and confectionery industries. It creates a level playing field for industries, provides favorable tariff differential to support investment in higher value chains, and promote welfare through creation of employment and increased revenue. So these seemingly will be the potential impact of the new CET 2022. From the Kenyan perspective, especially that of the Kenya Manufacturers Association, the promotion of local manufacturing, value addition and industrialization is also expected to boost the realization of the benefits of the, African continental free trade area through encouraging intra-regional trade. So this is a right step in the direction. The CET is also a good strategy to stop, and this is important for us, it's basically a good strategy to stop negotiation of double tax treaties with foreign states where low tax rates are agreed, which in the long run can make the East Africa region a dumping ground of substandard goods and products. So as a tax practitioner, I see the new CET as strengthening tax sovereignty and protecting local industries. Of course, there is the adverse side to these new tax rates. The burden may be and is being placed on consumers. We are already hearing from the Kenyan and Ugandan enterprises as well that the new tax has pushed up the cost of importation, spilling over onto basic commodities. So for example, for Kenya, and this is there in the newspapers for us to also access, importation of wood products is a key concern. And this follows the Kenyan legal framework that prohibits logging due to the country's climate mitigation plan. And the increased tax rate on wood products is raising concerns that the CET ban on imported wood is fetching the same price as finished furniture already in the market at 35%. So the impact of this is that the Kenyan manufacturers of furniture, they will probably increase the prices of their wood products to mitigate against the increase of import duty on raw materials used to produce furniture. Yeah, we also have to consider the new CET in the context of our current socioeconomic realities, and we have to assess whether our governments should revise some of these rates for products that are affected by these realities. I do not know to what extent this is achievable, since stay of applications on CET implementation have been removed. Now, the rising cost of living due to the global events, the Russian invasion of Ukraine, higher crude prices, we're still feeling the aftermaths of the COVID-19 restrictions, the inflation that is there and the dollar shortages. These will all complicate the implementation of the CET, more so for sensitive items, right? And the CET does speak of some of these sensitive items such as rice, milk, wheat, and so on. These are not being produced in sufficient quantities locally, and exports actually make up for the deficit. So placing these items at a duty above 25% while intended to protect local industry from competition is really, in my opinion, not looking realistic. Now, other implications on CAT implementation, of course, is inflation. This has implications on the purchasing power of the nation and people themselves. The Kenyan shillings depreciated by about 7.5% against the US dollar between 2019 and 2021. Now, the depreciation of the Kenyan shilling negatively impacts the manufacturing sector, where we have our local industries, because of its heavy reliance on imported raw materials and intermediate inputs for processing and capital goods for investment. Now, this is likely to lead to increased taxation nationally. And this is evidenced by a reduction of fiscal incentives, in other words, tax expenditures. So we're looking at a national fiscal shock as well, if we're not very careful how we implement the CET. Nevertheless, CET forces local industries to become more competitive and foster regional trade. I'd like to give you an example of Bangladesh and Vietnam. So Bangladesh, for example, when the country was discussing its position in the South Asian regional economic integration, it forcefully protected its garment industry by increasing tax on imports of garments. Today, Bangladesh produces ready-made garments, which constitute about, I think, 84% of total exports, making it the second largest exporter of ready-made garments after China. So similarly, as part of ASEAN, the member states increased tax rates for smartphone importation into the region, and this pushed Vietnam to become the leading export commodity for smartphones and earned about 45 to 50 billion only in 2017. So even though both Bangladesh and Vietnam have governance challenges and have a one-engine driven manufacturing sector, they are proof, right, that a move towards CET or a similar harmonized tax regime or similar harmonized tax rates advances local industrialization. And that's what we want. This is the Africa Union Agenda 2063. This is Kenya's Vision 2030 and the Big Four agenda that we have been, trying to capitalize on. So even when we look at Kenya, the Kenya Manufacturers Association, they themselves have confirmed that the 35% as the rate for the fourth tariff band will promote industrialization, will incentivize industrial investments, will actually discourage dumping and help protect local manufacturers. So there's a win-win situation for us. Now, my learned friends, generally the cost of imported finished goods will go up as a result of the new CET, right? But where locally produced alternatives exist, then we expect to see such industries grow since their products will be relatively cheaper. Now, if I was to give you an example of the EU, for the EU, a CET model has worked because it has made it easier for the bloc to negotiate trade deals. For investors, dealing with the entire East Africa population is more attractive as a return on investment than dealing with individual countries, right? So with this new CET, there is a potential inflow for foreign direct investment, which is necessary for our economic growth. For the EU, CET has actually protected their local industries, and these countries, the global north, has now become an industrial hub, an industrial power. So just by an example, suppose, and you can think of this in the context of either Kenya, Uganda, Tanzania. So suppose Germany, right, without a CET, had a 30% tariff on the import of steel, and Ireland had a 0% tariff. Now, in this particular case, think of a US firm, right? The US firm would export the steel to Ireland or set up a factory there and then have the steel transported from Ireland to Germany. So in that way, the US firm can export to Germany, but benefit from Irish tariff rates. A clear case of tax avoidance, right? So this is why a CET is necessary to harmonize the rules to check the country of origin and avoid this inefficient tariff avoidance problem. This is a reason why a common external tariff makes the most sense if you truly want a free trade area, right? That's also fostering the African Continental Free Trade Agreement coming into force, and also, promoting a strong economic bloc for Eastern Africa. So these, ladies and gentlemen, are my views on CET at the point of which it's going to be implemented, and later on we begin to assess to what extent do we see either adverse or good implications following the implementation. So back to you, Chair. Thank you very much.
Thank you, Lyra, for a very spirited presentation. I believe you needed a lot more time to go through this because you went through the whole spectrum of the advantages and of the downsides and international experience. Thank you so much. There will be questions for you, of course, but I believe, I think Jonathan may have had time to go through some of the questions and make some answers before the then comes in. Jonathan, are you ready, or do we dive straight into the Den's Fashamal's presentation?
Okay. Thank you, moderator. Let me start with the one on the FCFTA. Actually, yes. What has happened is that we have revised, because we had already submitted an offer from the partner states, but because of the new maximum tariff band, the offers have been revised for FCFTA. So, and the Secretariat in the process of finalizing the report to submit to the Secretariat. So I don't know whether I've answered that. Then I've also seen, this is just a comment, in simple and practical, what does this mean for an exporter of meat to DRC, Kenya, or Rwanda? Okay, okay, the common external tariff means that for goods which are produced within the region by partner states, and the countries you are mentioning, DRC, Kenya, and Rwanda, they are partner states. If they are exporting to another partner state, those products, they will not be charged any import duty because they are trading within the region. So the external, that's why I call it the common external tariff, that it applies for goods which are coming from outside the region. So if these countries are trading with amongst the member states, they are zero rated.
Lyra, maybe, Lyra, would you want to take Edward Baraba's question about uniformity and harmonized application and administration of tariffs and administrative rulings? Maybe you can tackle that together with Jonathan, and then after that we shall have the then coming in straight.
Okay, so what I would prefer to do is that I would like to type in a comprehensive answer for him on the Q&A chat box. Is that okay? I can even share some links that could help him get better information on this.
That's very okay, I guess. Edward, you are happy with that?
Thank you.
Jonathan, you had finished or not?
No, actually, for that question of Mr. Edward Baraba, I think my colleague will respond. Then what are the implications? What implication does CET have on medium, small, and micro enterprises? Okay, the goods which are, because of the new rate, it is expected that the goods produced by the medium, small, and micro enterprises, there will be a reduction in the importation from outside the region and an increase in the trade across partner states under that category. So the implication that, okay, we need time to monitor, but we expect an increase in the trade among the medium and small scale enterprises. across the region for the products they produce, which fall under that category.
All right, thank you, Jonathan. I now invite Dioden. His name has been a challenge to my tongue for some time. Nzafashwa Nayo. Nzafashwa Nayo, who is a partner in ENS Africa, Rwanda. Please, roll on.
Thank you very much, Cephas. And now at this time, you know, now you pronounced it correctly. So thank you for trying. So I will start with a general comment on the new common external tariff of the East African community, particularly the key drivers for introducing this fourth band. So Ronald Mason, Jonathan spoke about the promotion of intra-community trade, environmental protection, and maybe controlling people's behaviors by charging more tax on luxury goods. But I'll focus on the first driver, which is intra-community trade. So this is really a protectionist approach that is being taken because local industries, which are, I would say, quite, you know, in the area stages in terms of, you know, advancement, have been suffering from competition, you know, against the product from the rest of the world, and this is really going to help them growing up and be able, you know, to get, you know, their goods, you know, purchased by the resident of the East African community. But the question here becomes, what would happen before these local industries reaches to a point where they can have sufficient output, you know, for the consumption of the ESC market. So what can be done in the meantime? And that's, I think, the main challenge, which was probably not thought about as this fourth band was being introduced. And the reason why I'm saying this, we have had instances where even before the introduction of the fourth band, we could have, you know, locally manufactured product being more expensive than what is being imported within the community from the rest of the world. So now, I think that's something that should also have been considered, and maybe Jonathan will get time to share some comments on this. But this is the main challenge. Now, in terms of implications, when you look at the type of product or the type of goods on which this fourth band are priced, they really include, you know, these basic goods, you know, that are needed for people's consumption, including foodstuffs, in general, hygienic and cosmetic products, beverage, or the likes. And the main implication this is going to have, and of course, in light of the prevailing circumstances where there are other factors leading to the increase in prices, is to exert pressure on consumers, because as you know, those who are familiar with indirect tax on this webinar. So these import duties are added on the price, you know, I mean, are factored in the price to be charged by the supplier to the consumers, and the consumers are the ones to, you know, to foot this, you know, as part of their spending. So and I can see this really as a challenge in terms of implication of the fourth band of the common external tariffs. Now, another issue I can see here, like in terms of implementation. So when we say that one of the reasons for introducing this is to promote the intra-community trade. So there is now an issue of effective enforcement of the East African Customs Union. So Jonathan alluded to that when he was answering the last question about exportation of, you know, this product in the other ESC partner states. But you would realize that much as yes, there is no import duties applicable on goods manufactured, or produced within the community subject to the rules of origin. So we have seen instances where this is not, being, effective or not. So I'm sure you can recall about the issue of importation of milk between Kenya and Uganda. So these are the kind of issues that we may have still hindering, the intra-trade community, which should be first dealt with instead of, increasing, I would say, much as of course it has its own advantage, but if these issues are not dealt with before, then, we will be in a situation where even the new common external tariff is not going to be, particularly this fourth band is not going to help anyway, because the issue, there have been a number of issues hindering the intra-community trade, particularly when it comes to the partner state being adamant to enforce it effectively. So, and this is in addition to other ways that may be used by partner state to protect local industries against product from other partner states, which shouldn't be the case. Some of them may use excess duties by applying rates that are on the product from other partner states that are higher than to what applies to products produced within those partner states. So I think this is also something that needs to be considered as people look into the strategies or the measures that can be used to promote the intra-community trade. And of course, bear in mind that much as the fourth band can help, but if these other aspects are not dealt with, maybe the intended result may not be achieved. So another thing is maybe what needs to be done by partner state, because promoting the local industry is one thing, but getting them to a point where we want to be able to sufficiently supply the community, the East African community, is another thing, and this may even take years. So I think there is a need for some of the partner states also. And maybe I'll talk to what has been done by Rwanda as a reaction to this new common external tariff. So a need to consider, let's say interim stay of applications, where they believe that indeed there are no sufficient quantities within the community, to satisfy the local market. And by way of example, for instance, I was looking to the ESC Gazette of 30th June 2022 about duty remission and stay of application that were requested by partner states, as ahead of the new financial year. So, for instance, Rwanda has now requested a stay of application on soap and refined edible oil, instead of applying the 35% under band 4, now we'll be applying 25%. So I think these are the kind of measures partner states also need to think about in the interim, pending, the reaching of the level of how self-sufficiency within the community, to relieve the consumers, because they are the ones who are going to be to suffer more, from these increased, import duties, to relieve them from that burden, especially that, in these days there is an increase in terms of cost of living. I think that's what I can share in relation to this new common external tariff, and particularly the fourth band. And maybe if there is any comment or question, I would be happy to take them. Thank you.
Mr. Nzafashanwayo, thank you so much for bringing out actually a number of those practical issues on the ground. Without repeating what you have said, the particular intra-partnership disputes should come to be highlighted. Milk between Kenya and Uganda, rice, Tanzania and Uganda. Many of us are familiar with issues around Katuna border. And as you said, when you get a protection of the local industries, and then you get the state of application to be an exception, whereby a lot of things which are protected, which are apparently protected, are brought in at very low rates to benefit a few entities which say they are manufacturers, when they are actually apparently bringing in physical finished products against everyone else, as you saw from the rice issue, which was like ring fencing a few entities to make a lot of money against everybody else. So you are kind of protecting inefficiency. But those are my views. Those are very good comments, Diodin. And I think you'll be free to answer any of the questions which are there. All the presenters will be free to make comments on the questions which are on the screen.
Sure.
I want to use that opportunity to thank you and also to invite Stanislas Chitimbo from Solid Attorneys to make your intervention. Thank you, Stanislas.
Yeah, thank you, moderator.
You are welcome, Stanislas. Go ahead. Is there a challenge on the audibility?
Yeah, am I audible?
Yeah, now we can hear you.
Right. Excuse me, I won't be able to switch on the video. My position is not audience friendly. But then I would like to first make a note that while ministers sat in Mombasa in May to discuss on the fourth band, the minister for Kenya, right after the meeting, despite the fact that they agreed on the 35%, despite the fact that they agreed on the 35%, she explicitly said that there should be flexibility in applying the 35%. I think she looked into variably between the regional bloc, considering each country has its own necessities. Now, we are discussing insufficiency of production, which should then invite exports from other countries. But then what we are looking at is protecting our local industries. But I don't think we have considered protecting investors. I look at the tourism industry, for example. If I take an example of Arusha, for example, there are many hotels routing from different countries around the world. Now, there are Arab hotels which fit in everything inside the hotel are imported from the Arab world. Now, if we impose such a high band, 35%, are we attracting investors or are we discouraging them? Now, that's in terms of imports that would go to construction. But then again, in Tanzania, the statistics show that we have immigrants of almost more than 200,000. Now, let's consider food for that effect. Let's say the spices for the Indian communities. Let's think of the beef from the Arab world. Let's think of the beef from Europe. Now, while these investors are coming, there are so many things they consider before settling in. Now, if someone is to order beef from Sweden, which is their home country, and they're here to stay for 10 years, and then they're looking at an investment of, let's say, $50 billion, and only food will discourage them from investing. Now, we are looking at raising revenue, but if these people would not come to invest just because of the tariffs we invested, what revenue are we looking at? So for me, really, my comments would be very brief, looking at on an invest. So I would ask Kenyan Minister for Trade that there should be flexibility in applying these tariffs. But then again, let's take another example on external tariff. If we are to say goods from Uganda to Tanzania will attract zero tariff, and then we have an investor from America who takes advantage of the Tanzania for free is 35%. Rather than we would say, let's think of another tariff which will make the investor remain at their home country and we will still enjoy income from their production. So really, looking at it, there are severe implications in terms of revenue because the figures that were demonstrated by our learned brother, that is revenue forecast. How realistic will it be saying that if we raise by 35%, we to earn 7.2. What if we do not earn that $1 million we are looking at right now? A discouraging investment. So that is. Moderator, I think I'm done.
Thank you so much. We had some challenges with hearing some of what you said, but I think you brought in a very important perspective of, again, further to what Dioden said, what is on the ground. Is this a real union like we want it to be, or do the different partners have a right to say whatever they want? If one of the partner states just saying we should have flexibility, how much flexibility should there be? If everybody is flexible, then what will be the end result? I think that was very important, although there is quite a lot we didn't hear from you because of the audibility issue. Before we dive into the open session, I think I would request the presenters to pick any of the questions which they think have remained unanswered. But before we go there, once again, and there was a question about administrative rulings, which I think the Secretariat specifically should address, whether they are binding on everybody, whether they are coming out properly or whether they are not coming out. But I also, on a different note, want to ask Jonathan, the ESC is focusing so much on the customs taxes. It's supposed to be a common market. How much effort is being made to harmonize the domestic taxes? You are free to answer that question at your leisure during this presentation. We still have some time. Is there any member willing or ready to address any of the questions which have been screened? If so, please go ahead.
Thank you very much, Cephas. I can see from Nicholas asking about whether there is any time limitation on the duty remission schemes, and he's stating that some are resulting into exemptions for a few manufacturers. So maybe to shed more light a bit on what duty remission entails for some of the participants who may not be familiar with this. So this is a scheme within the ESC Customs Management Act, where the Council of Ministers may allow that, 0% late or even a lower rate compared to what is in the common external tariff applies on the importation of inputs required for the manufacturing. And this would even, of course, come with additional conditions, like the fact that, goods to be manufactured from those inputs must be exported out of the community, and as you can imagine, the whole rationale of that would be promoting exportation. So in most of cases, you would see that these come with time limitations. They would say maybe for 1 year. Generally, actually, it's for 1 year. But of course, depending on the need of each and every economy, so the tendency is that you would see these, being recurring, like each and every year, putting the same request to the Council of Ministers. And that's why you would see them appearing like as a never-ending, exams. But in principle, they are subject to some time limits, but they may be, you know, renewed depending on the needs of each and every partner state. That's the answer I can provide to this question.
Thank you very much. Any other person ready to dive in? The questions available. Jonathan?
Yeah, actually, the question on administrative rulings has been really ably responded to by my colleague fellow panelist Leila. Actually, the administrative rulings are national in nature. For example, they can cover a wide range of decisions. They might be valuation, classification of goods, and but in most cases, the practice in custom is that when they make a ruling, it is specific to a particular consignment or importer. That's why they don't publish them. So even us at the EAC, they don't give us that information. So in most cases, the administrative rulings are not general, such that you can rely on an administrative ruling which is valid, say, for a whole year. So that's where the challenge is. Maybe that's what I can add to what my colleague has already responded to.
Thank you, Jonathan. Alaira, are you able to highlight a bit about what you sent? You said you are going to type. Maybe you can just briefly educate everybody who is free to listen.
Oh, yes, it did. I'm very sorry. I'm so distracted because we have Raila about to give his address. So, you know, it's quite interesting back here at home. Anyway, Edward had asked a question, and I think also Jonathan has responded, right? That we have this regional integration, right? First of all, you know, it's all about becoming post-colonial states. So you have national sovereignty, and every national authority decides what its tax structure should look like and how its bilateral, multilateral relationships with other countries have to be structured into. Then we had the EAC. Now, with the EAC, we had some undermining of our tax sovereignty and our fiscal system. It had to be subordinate to what the region actually thinks. So then we had the EAC, and it came up with its own harmonized rules. Now, we have the protocol. And the protocol lays down a number of governance issues. One of the issues is that the customs unions have to be harmonized. There has to be a particular way in which we exchange financial data and trade data, particularly so related to customs. Now, we don't yet have that harmonized monitoring system at the EAC level, whereby between the member states' border areas, whatever transactions are happening are automatically being lodged onto a digital infrastructure somewhere. So because that is missing, the fallback position is that the burden falls on each individual partner state to make this reporting and to ensure that the administration is being properly handled. So even when it comes to the application and administration of tariffs, as Balaba has asked, right, in terms of the different member states, how do we get to know that they are being uniformly handled or dished out? And how do we, for example, figure out whether the administrative rulings that provide the manner in which these tariffs are applied and administered, that information is available for public use by taxpayers. So if you go to the EAC website right now, you're not going to get this information. Now, as a lawyer, if you want to force this information out of the EAC, you probably have to adopt the litigation approach to go and first petition the council to provide some of these rulings, and the council will simply tell you, go back to Kenya Revenue Authority or go to the Uganda Revenue Authority for them to be able to provide you with this information, because that's the level at which, in terms of the governance structure, that you can get access to such reporting. So until we have this harmonized system, the monitoring system available at the regional level of the EAC, we cannot access this information publicly on the East Africa portal. It has to be through national governance structures. So that's what I wanted to say, Chair.
So, Raila, As
Yeah.
a member of the tax committee,
Yes.
what are we going to do? What is our intervention? How are we adding value? This is supposed to be
Well,
our work. We are going to say we managed to move this needle. Tell the members what we are going to do to do that.
It's investing in the infrastructure needed. So Article 5 of the East Africa Community Customs Union Protocol, it basically relies on partner states to exchange such information. And we know that ATAF, the African Tax Administrations Forum, they are a collective body for all revenue authority, the heads of revenue authorities, to sit down together and come up with a digital software through which we're going to have continental exchange of tax data, right? So this is being done at the continental level. So as East Africa, we should probably get each head from the East Africa Revenue Department and ask them to follow up with ATAF to also present that model for our specific regions. Yeah, so we need investment in digital infrastructure. That's key. We need to have this software through which all Kenya Revenue Authority, Uganda Revenue Authority, Tanzania Revenue Authority would be able to automatically feed in cross-border tax data into this portal. So for that, my dear senior, it's beyond my hands, because it depends on how much the government is willing to invest in terms of paying into the EAC to purchase such software. Perhaps we need to start looking into the European Union and other, developing countries, regional blocks like Asian, to see what sort of software have they employed that facilitates this information for them. And then best practices, we try and model a similar digital software for the East Africa community, and therefore, test it out and then get that data. So probably that's what I would want to say about this.
Thank you for opening our eyes, but I think hoping that the tax bodies will help us to get this is like asking
Good
the
luck.
monkey to seek the forest to be cut, because my experience with these rulings, even WCO, is not very friendly to the
Absolutely.
importer. The WCO also tells you that they'll get you ask for an opinion from WCO through the revenue authority. So how much cooperation you can get for that, I think
it's tough. But you see, the good side, my dear sir, is that the United Nations FACTI panel, in one of its recommendations, it has proposed a sort of a central monitoring system of all tax data for all countries. And they're going to make this portal open to the public. But by the time the UN does something about this, it's going to be another 10 to 15 years, because again, we're having, disagreement at the OECD level. So there is this move towards digitalizing tax data and financial flows for the continent. The UN is trying to lead on it, but for the UN to lead on it, we first have to pass the UN Tax Model Convention, which will never happen, unfortunately. So we can try and do this from East Africa's perspective. Kenya is always leading. We already went ahead and proposed unilateral measures on the digital service tax. The Kenya Revenue Authority has a very good Orbis software that tries to tap into this data from the digital sphere. So maybe, using Kenya Revenue Authority, they have this knowledge platform sharing with their KESRA. Perhaps as the East Africa delegation, we should be able to push other revenue authorities to move towards KESRA, to ask them to show them the digital platform that they are already using to tap into digital tax data online. And maybe that could be something that can be used at the East Africa level to implement Article 5 of the protocol. So there's a lot going on, but it's again about money, it's about political commitment, and it's also about, the extent to which we are prepared in terms of the infrastructure that we have across all partner states.
It is also about being able to be around 15 years from now. Thank you for that. At this juncture, I would request the presenters to make their parting shots. I think almost every question has been addressed. David, are we on board? Has every question been addressed? And then if each of the...
Chair, yes, almost all the questions have been looked at.
We can have parting shots in reverse order, starting with Stanislas, if his system is fine, if he's available. I think he was having challenges with his network. If Stanislas is available, he can give us parting shots.
Yeah, I'm available. I'm sorry about my internet today.
Yeah, we'll make it through. Please, you are welcome.
Yeah. So I mean, conclusively, what I'd like to say is the tax law committee. I think based from our previous discussions and the ongoing discussions within the committee itself, I think if we seek official recognition within the EAC block and work regionally together, we would make quite a huge impact in as far as tax is concerned. So I leave it to David and Senior Birungi to see if we can get official recognition and then we can get official functions. I think we will make the difference. So that's just my conclusive remark.
Very good, very good. That's my wish too. Thank you so much. Dioden?
Thanks, Cephas. Mine is not really different from what Stanislas mentioned. So I think there's a need to push for this recognition by the ESC, you know, as also like a kind of think tank or like a body that should be contributing meaningful to all these developments. And if it was to be achieved, then that's why that would give more sense to what we are doing as the members of the ERS Tax Committee. Thank you.
Thank you. Raida?
Yeah, absolutely. So I think this was a great discussion. It's a good starting point to observe the market on the implementation of CET and the sort of fracas it's going to cause for local industries or the kind of growth it will help steer for local industries. I think this just hit my mind right now as a parting shot is that we have to be a bit vigilant with the national tax policy in the works by Kenya. So we're going to pass our own national tax policy subject to the constitution. And this policy allows government to review after every 5 years all taxes and tariffs. So from my understanding, I think this may impact the CET. So its practicalities, the practicalities of CET should also be revised accordingly if it doesn't really suit our market. In as much as we are regionally trying to integrate, we should also be very, very protective of our own national fiscal spaces. Thank you.
Thank you very much. Achilles, you have something to say before Jonathan comes in? And then we get a wrap up from David. Achilles?
Chair, I think I'll be the one going, yeah?
Okay.
I just want to clarify one thing that the East African Law Society has observer status with the EAC, and that is with the East African Community. And therefore, what this bestows upon us is the ability to have a say in what is going on or in some of the policy development processes before they are actually adopted. What the practice has been is we get a chance, normally at policy development process, before even Council of Ministers gets to discuss some of these issues, through the sectoral council to have input into these processes. It's true that sometimes the EAC does not really openly share this information, which makes it a bit hard for us to participate. And now that Jonathan, who is in customs, is here, probably it's a new chapter so that we get information earlier. We share with committees like the Tax Law Committee or any other committee, depending on the relevant subject matter. And then it's hard. On other special recognition, I don't know whether the committee can be recognized as the committee itself, except through ELS. But that is something that we can look at and see how to really have our voices heard. But being heard through input processes, I'm aware of the national tax policy in Kenya. We might want to develop and have our input heard earlier. Laila, you will lead that so that when the right time comes and we are required to have input, we can then, as a society, develop a policy position. And absolutely. Then, but for now, we are recognized. We have observer status with ESC, and we have a say in most of these policy and legal processes. So, in case someone has input they want to share with the ESC, we are always readily available. to use ELS channels to be heard at official ESC levels. So thank you very much to the experts here. I think this has been one of our more lively discussions. Our participants must have really enjoyed and learned a thing or two about the common external tariff. And as you go out to advise your clients, I think the lessons from here will be very helpful. We are going to have the video of this session uploaded on our YouTube channel. So in case you missed something, or in case you want to refer to it later, you can just click East Africa Law Society on YouTube and you will get the whole recording, and you can extract whatever you need. It's also going to be put on our socials, so it's going to be readily available. I'm going to request that the presenters that had presentations share with us, so that as we share the report with the attendees, we can actually attach them. So thank you very much. Back to you, Chair.
Thank you, Achilles. Jonathan, some parting shots.
Thanks, Chair. As I mentioned in my presentation, that the common external tariff is what is common now is in the application of import duty. You asked that what are we doing when it comes to harmonization of other taxes? Yes, there's an initiative to harmonize the domestic taxes, but the process has been slow because of nationality issues. Some countries are not ready to cede power, for example, they still need that flexibility to handle, for example, VAT, excise duty, and other applicable domestic taxes. So we still have a challenge there, but I'm just calling for optimism that we need to, that the intended objectives of the fourth band application will yield the results that were assumed to be achieved. So I'm hopeful that we'll be able to achieve the intended results of increasing production, employment in the region. Thanks.
Before you leave, there are issues of COMESA, SADC, ESC, cross-cutting issues. Some comments on that?
COMESA, okay, I know there are issues to do with the multiple membership of members of some partner states. Yes, there's still that challenge of some partner states being members of, say, SADC, others are members of COMESA, and it has an impact on the application of the CET. So, but we had there's been a process which has been going on for some time of the tripartite to harmonize the positions so that it become one free trade area. So I hope that maybe that one will materialize later. Thank you.
Thank you so much for the wonderful presentation. David, if I hand over to you, I would like to thank all our wonderful presenters and our wonderful listeners for the wonderful comments. I think it has been very enlightening, and it would not be asking too much to say that we need the follow-up of this kind of presentation. I wish to thank you so much for listening to our very able presenters and attending to the ELS Tax Committee. So I hand over back to David to wrap up the session, and I wish you all the very best. As Raila is looking forward to listen to Mr. Raila Odinga. Wish you all the best, Kenyans, for having had a very wonderful election, albeit nearly spoiled at the end.
Thank you very much, Chair. I just want to join you in thanking our panelists, the team of experts from the ESC, from the University of Nairobi, ENS, Rwanda, Solid Attorneys, and yourself, Chair. I think a lot of work was put in by the ELS Tax Law Committee, so much appreciation to you. And also to appreciate our participants who have been online since 2 p.m. Thank you very much for taking the time. We are looking forward to engaging you. And like I said, we are going to share details of what has been presented here today through your emails and through our official social media handles. We are looking forward to hosting you again. The Tax Law Committee is organizing many other future events. So we look forward to once again welcoming you. With that, and on behalf of the ELS Governing Council, I beg to not necessarily close the meeting, take it back to the chair who will close it officially. Chair, just close it for us officially.
Closed.
Thank you.
Everybody. Have a good evening.
Have yourselves a nice afternoon. Thank you.